Good afternoon, everybody. It does appear that we are now at the top of the hour, so let's get started. Thanks so much for joining us for today's Garris HIIT webinar titled How to Conduct a Cybersecurity and Data Privacy Controls Vendor Audit. First, some logistics for this HIIT webinar. All participants will be on mute. This webinar is being recorded. We're going to keep introductions very short so we can get right into the webinar. First, we have Senior Partner John Levenick of Garris HIIT, a seasoned lawyer who focuses on consumer finance, capital markets, and technology. John is a nationally recognized speaker on emerging technology, consumer finance and mortgage lending, regulatory compliance, securitization, and the capital markets. John is joined by guest Scott Ingram. With over 20 years of experience in information security and compliance, Scott is a seasoned cybersecurity leader known for driving innovation and strengthening organizational defenses. He excels in identifying vulnerabilities, developing remediation plans, and enhancing security posture across diverse teams. That is our brief introduction of today's speakers. John, why don't you kick us off?
Thanks, Shauna. Good afternoon, everybody. I appreciate your time today. We put this together in very short order, and the feedback that we got immediately was immense. So we're very excited to be here. The goal today is to discuss with financial institutions what their obligations as a regulated entity are as it relates to vendor management, specifically ensuring that your third-party technology providers and their downstream technology providers adhere to your regulatory obligations as a prudentially regulated entity, and to give financial institutions and vendors a more comprehensive understanding and view into what a comprehensive cybersecurity audit would look like, what it needs to contain, and the artifacts that need to be retained to evidence this function when regulators start assessing your infrastructure, your platform, and questioning to what extent you audit your technology providers, and to what extent your technology providers audit their technology providers downstream. So that being said, let's kick off. From a very high level, the elements of an audit start with your understanding of your infrastructure. You need to have a comprehensive and clear picture of what your IT stack looks like, where your data resides, where your data flows to, where it enters, where it exits, and that during this whole process, your data is appropriately controlled and preserved and relegated to only the persons that need to see and view that data. The key to a very successful audit with a vendor is setting appropriate expectations. As a financial institution, the better information you can provide to your vendors in advance, specifically what documentation you're going to request in advance of an audit, will ensure that they're prepared and that they have the requisite information well in advance to make the best use of their and your time. Your approach to an audit, these audits should be systematic. They should be thorough and comprehensive. These audits should have a process that's repeatable, clear, and it establishes clear and unequivocal obligations and understanding between the parties regarding what your vendor's obligations are in supporting you on a day-to-day basis. Remember, as a financial institution, you are the regulated entity. You are responsible for the protection of your consumer data. Your vendors need to understand what your regulatory obligations are, and they need to mirror that, not only as they support you directly, but with their vendors, their third-party technology providers that are part and parcel to the services or technology that they provide. So you will need to effectively have certain tools, and you may require the use of certain tools in advance of an audit. There are commercially available tools that you can use to get a better understanding of which of your vendors may be at higher risk than others, depending on what they do, and also based upon publicly available information. As we get further in the presentation, Scott will most certainly be able to talk to you about what's publicly available and what you can do in advance. And then finally, what to do with the information that you identify as part and parcel to this audit. When you get findings, what do you need to do? What actions do you need to take? And how do you see this through? So obviously, the audit is vital. You're all here. You understand that the audit is vital. But at the bottom line is, as a financial institution, you have an obligation to protect your consumer data. You have an obligation to not only protect the consumer data, but comply with your regulatory obligations. Meaning, if you are a licensed entity by the state of California and a licensed entity by the state of New York, you need to understand what are your obligations to fulfill the regulatory requirements for the state of California, maybe under the CCPA, and that of the New York DFS, specifically Section 500. Your cybersecurity controls audit is not only important for regulatory purposes, but for business continuity, meaning you need to understand your vendors, their controls, but also their redundancy. What happens if a critical vendor goes down? What happens if they have a technology failure? What do you do? What do you set in motion? What is your plan for business continuity? And what business continuity controls and plans do your vendors have in place to ensure that you can continue providing services to your consumers? Finally, liability protection. We all know the importance of cybersecurity insurance. Cybersecurity insurance may have been reasonably easy to obtain in the previous years, but as more and more claims start becoming, it becomes more prevalent for institutions to get bricked or to have losses. Insurance is going to get tougher to get, and insurers are going to be auditing you as well. So not only will your state regulators be auditing you or your federal regulators, but your insurance providers will also be auditing you to assess whether or not you are insurable and what your risk might be. And obviously, the security of integrations. As we move towards a more open banking platform, more open banking environment, interconnectivity and interoperability between technology needs to be understood. Not only what consumer data do you control and where do you see it going into your controlled third-party service providers, but where are the APIs going in and out? Where are your obligations to manage and ensure the proper controls over data once it leaves your infrastructure? Once it leaves your infrastructure, does not stop, does not end your liability. You need to, at times, ensure that once the data leaves your infrastructure, that it securely gets to where it's going. And once again, that's your obligation. The regulatory framework, from what I've experienced, is the primary driver behind cybersecurity concerns of financial institutions. Meaning, my phone rings because I've got financial institution clients that are concerned with pending examinations. They get an advance notice of the examination. The CSBS has been so kind to offer all the state regulators formatted letters for cybersecurity audits, and CSBS will continue to train state regulators on how to conduct cybersecurity audits and data privacy audits. So the regulatory framework is vital not only for the state regulators, but for other critical pseudo-regulatory parties. When I say pseudo, meaning if you deliver to Fannie and Freddie are going to be doing audits on your vendor management controls and your assurances of cybersecurity data privacy downstream with your technology providers. FHA and VA, same thing. You know, I've identified where these obligations exist for Fannie, Freddie, Ginnie, FHA, and VA. But it's your obligation to understand what they require of you and ensure that as part and parcel to your cybersecurity audit program, that you have the appropriate auditing information, but also obtain and retain the requisite information to evidence sufficiency of your audit. Worst case scenario, Fannie and Freddie don't like your controls or you lack controls. You may be put in the penalty box temporarily by Fannie and Freddie until you get the appropriate understanding of your critical vendor's ability to control your consumer data. So that's a business continuity concern. So you can see where the regulatory and the pseudo-regulatory obligations lead into the continuation of commercial business or commercial practices. And I apologize in advance for my tempo. This is a 30-minute speed webinar. Let me see here. All right. All right. Whom do you need to audit? As a financial services provider, you directly and indirectly interact with many third-party technology and third-party service providers. Obviously, it starts with a CRM, rolls into your point of sale platform. Your point of sale platform may be independent of your loan origination technology, and then your doc prep vendors. These may be three distinctly different organizations that you maintain integrations into with your enterprise technology, whether it's an LOS or your core infrastructure. AMCs are another third-party vendor that gets NPI or PII pushed and passed to them, that you have an obligation to ensure that they protect the data, and they protect the data downstream with their participant appraisers. Title and settlement service providers. Title and settlement service providers are a very, very of interest area right now for cybersecurity data privacy audits. I hate to say it, but law firms and attorney states, law firms are at times the worst actors. Law firms are the settlement agents that are least likely, believe it or not, to have the requisite controls in place. Quality control and due diligence providers. Once again, these are third-party service providers that you might not think of as a technology provider, but they're a service provider. They're a technology-enabled service provider. They take possession of consumer data. Not only do they take possession of it, they retain it. How long do they retain it for? What is their data policy with purging and their obligation to protect and preserve the integrity of that data, and for how long? Once again, your investor might dictate that you as an originator use a certain quality control or due diligence provider. That doesn't absolve you of liability of ensuring that that vendor has your best interest in mind and controls and preserves your consumer data appropriately, even though you didn't choose them, you didn't select them, and that you're using them as part and parcel to your loan delivery obligations to the private secondary markets. And payment processing services. Ordinarily less obvious. Most payment processing services have PCI DSS controls in place. But for those of you that control the treasury function of loan funding, and as lenders start controlling and getting the requisite tools to control the treasury function of funding, payment processing services are vital. Preparation. All right, first and foremost, you've got to classify all these third-party technology providers and vendors by criticality. What type of data do they get? How long do they hold it? And what are the contractual obligations that they have to you as a third-party service provider? You need to understand whom has access to your data when it's under the control of your third-party services providers. You need to have a comprehensive understanding of their frameworks, their compliance certifications, their SOC reports, any type of documentation that they could provide to you to evidence the sufficiency of their controls against a generally commercially recognized standard. Everyone uses SOC 2 Type 2 as a standard as a third-party service provider. That's great. But you've got to ask yourself, does SOC 2 Type 2 cover all of your concerns as a financial institution? Just because they have a SOC 2, does that allow you to be assured that they're protecting everything downstream? Quick answer is no. And to what extent? You've got to figure that out.
And also, John, just to echo in here, it's all about understand to your company DNA, understand your data. Is it crown jewel data? Meaning crown jewel is the most sensitive data. It's client data. It could be, social, fill in the blank from that, or it could be public data where it's a screen capture from Google Maps. It's all about understanding your data and where your data resides. And then also, SOC attestations are good, and it shows that they have both hands on the steering wheel. But you still want to take it a little deeper and look at, hey, what are you doing for business recovery, disaster recovery, business continuity? Because if we leverage you 100%, we could be impacted if you don't recover to 72 hours and stuff like that. So it's a conversation that you want to build in your company DNA when you go through this phase internally and then externally.
Scott, you might find it interesting that I know of financial institutions that have been presented from their vendor SOC 2 reports from their cloud service provider, thinking that that's sufficient to represent the controls over their data. But when you work with a cloud service provider, Microsoft Azure, Google Cloud Partners, AWS, they protect your data only to a certain extent. And your obligation in working with them is referred to as what's referred to as a shared responsibility model. You need to understand where your controls are, where your controls end, and the cloud service provider's controls start.
Exactly. Basically, in the short of that, your controls are extended to Microsoft Azure or AWS or whatever it is. You need to build a clear demarcation of who's responsible for what, but you have to make sure that the controls are looking at all aspects of the cloud provider.
And finally, here is understanding the scope of activity that the third-party service provider provides based on their function. Are they a critical provider? If they're critical, what is their redundancy? What is their business continuity and disaster recovery program? What is your business continuity and disaster recovery policy in the event that a critical vendor fails? Do you have a secondary provider that with a push of a button can be stood up and fulfill their obligations in the absence of their ability to support you? So cybersecurity and data privacy entails business continuity, because at the end of the day, a cybersecurity risk is being bricked, meaning a ransomware situation comes in, a hacker penetrates, they lock your vendor system down so your vendor can't conduct business. What does that mean to you? And how do you ensure that you can continue on with commercial activity?
Right. And then the other aspect, you want to socialize this across all stakeholders. You don't want to build a island mechanism or rogue IT or rogue business functions. You want to make sure everyone is on the same page, meaning we're using company A for this type of borrower service data processing, and everyone comes to an agreement. That will prevent any type of data leak, data loss, and any type of incident that's reportable also.
As part of your vendor management program, traditionally a risk department or compliance department manage this. But now in the world of cybersecurity and data privacy, the key stakeholders from your organization need to involve a collaborative effort between IT, legal, ops, and compliance. So understanding who needs to be at the table to address all of your organization's concerns through this vendor management, vendor oversight.
Exactly.
So what is the documentation that you will need to start and through the process of the cybersecurity audit? Obviously, all the audit planning documents are necessary. These are the documents that you might provide to your vendor well in advance of the actual meeting that you conduct to allow them to collect the requisite information to provide you. So you have an understanding of what areas to focus in on based on your assessment of, all right, well, they're missing their business continuity disaster recovery plan. Let's be sure that we address that in a follow-up in our meeting with them. So you need to have the scope, the methodology, the timeline and schedule. It's important that you impose a timeline and schedule on them because vendors will drag, delay, and this will turn into a massive time suck on your part. Once again, you want to be as efficient as possible because you've got limited resources and you do not want to commit unnecessary amounts of time to this vendor management oversight, but you want to be thorough. The vendor assessment documents that are required, obviously, you need to understand your technology providers and their risk, but your vendors need to provide you with the same documentation. They need to have the same criticality assessments on their technology with their sub-vendors. We refer to that as fourth and fifth generation. So your LOS platform is the third generation technology provider. The fourth generation might be the the vendor that's conducting services. The fifth might be the vendor that supports your vendor that's providing you with services. So your obligations don't stop with your vendor. They pass on through to everyone that has visibility into or access to or possession of your consumer data. This is always best obtained through data flow diagrams. I'm a big fan of visualization, and as a financial institution, you need to have a workflow, a data flow understanding of where your data enters your system and every place that data might exist, whether it's replicated and stored, whether it's passed through to a third-party service providers, where it goes, and so you can better represent that you've identified the areas of potential loss and potential risk all the way downstream.
And also, just to echo into that, also you want to know geologically, where does the data reside? Is it within US borders, or, as we all know, there's offshore, nearshore, and there's a lot of data protection requirements with the data. You just got to make sure, where does it reside and how does it workflow with where it resides.
That's a excellent point, Scott. If you are an OCC regulated bank, you may very well have an obligation to ensure that your consumer data stays within the continental United States, doesn't go offshore. But then you might have questions. Well, if the third-party service provider is located offshore, nearshore, and they VPN into my system, does that count as data? Am I in violation of my OCC obligations of keeping data resident within the territorial confines of the United States? These are questions that you need to be able to answer and defend, and these are practices you may need to defend in the event that a regulator asks you, based on the nature of the service provided, well, isn't that entity offshore? How do they access data? Compliance documentation is vital. You need to not only have the checklists and the results, and you need to have procedures on what to do and what actions to take based on your findings. Once you've identified a deficiency, you need to act on it, and you need to see it through to resolution, and you need to document your activities all the way through. People, service providers aren't perfect. There may be defects, there may be flaws. As a financial institution, you are actually the only entity ensuring that the vendor's IT systems and controls, ensuring the integrity of their controls. Third-party service providers aren't directly regulated. They only do what they need to do to keep the relationship with you as a financial institution. So as a financial institution auditing vendors, they'll fulfill your needs, but you can't presume that they're doing the right thing on your behalf, and they will do what they need to do to retain your business. Obviously, keeping records of insurance coverage, certification attestations, reviews. Remember, something like a SOC 2 Type 2, that's a point-in-time representation. It means at the time the SOC 2 Type 2 was issued to the service provider, they had the appropriate controls in place. Infrastructures are dynamic, so these can't be, in my opinion, done once a year. They need to be done and reassessed and reviewed, and you need to have the contractual understanding between your parties. Anytime that there's a material change in their critical infrastructure, they need to report it upstream to you, because a material change in their critical infrastructure may make their SOC 2 Type 2 no longer relevant, may not applicable.
And that's a good talking point, John, because, in my past, I dealt with the vendor. Yes, we have our SOC 2 Type 2. I looked at the date and timestamp on it, and it wasn't relevant to the current year. So I pushed back and go, do you have a bridge letter? And they did not have a bridge letter. So, you always check, and do not assume.
And finally, well, not finally, but another big part is disaster recovery business continuity. Many times when a financial institution audits a vendor, they take verbal representations from the vendor as to, do you have a BCDR, Business Continuity Disaster Recovery Program, BCDR? Sorry, I live in acronym land. Do you have a BCDR program? Yes. Well, show me. You cannot trust in verbal or spreadsheet representation of controls. You need to be in a meeting at the table with them or at the virtual table with them and have them walk you through these controls and give you in real time evidence of these controls. Long gone are the days of saying, yeah, we have that. Yeah, we have that. When come to find out, believe it or not, vendors don't always tell the truth. I know it's hard to believe. So you as a financial institution need to ensure that this is that this is properly evidenced and that you have eyes on it. 5 minutes, I know, Shauna.
Okay.
One last 30 seconds or less touch point on that. The policy is great that they have a BRDCP plan, business continuity plan, and stuff like this, but take it one step farther. Show me a test result of your business continuity that's relative to the current year or whatever. If it's within a year, show me, right? And that will demonstrate, yeah, they're actually testing what they say on paper.
All right. So here, this is the audit process. And I jumped a screen. All right, the audit process. Scott, why don't you walk us through this quickly?
Yeah, sure. I'll go through step 1 and 2. So the key is in the process, you want to document and understand all the data touch points. That's very critical. And then from that, is there a kind of, I'm a visual guy, do you have a workflow map of integrations, meaning is it A, B, C, or is it A through Z? You need some representation of that to understand where the critical or crown jewel data's workflow is. And then from that, the big one is review e-signature and digital closing process. Make sure that is in place and it is relative. From that, you want to look at the security controls, all the different domains. You go through the controls, okay, BCDR. Okay, within the control, did you test it? And then encryption. Go through the encryption. You don't have to be a scientist to go through encryption standards, but you have to understand, are they using relative encryption standards? And then also what's critical with encryption standards is to understand where is the key to the encryption. Can you encrypt with your said company's own key and have escrow and stuff like that? And then lastly, out of this, understand access management practices and controls, who has access to the data from internal staff, contractor staff, fourth party, third party, fourth party outsourcing and stuff of that nature. And then into step 3, I've said it earlier, review the business continuity, take it one step farther, show me an executed to your plan. Was it a tabletop or was it actual? Look for those type of artifacts. Incident response, look at their policy, how they handle when there's a significant event. And then also, do they test their incident response? That is critical. Disaster recovery, I spoke about that earlier. Make sure from the policy that they test the policy and test what they say they do. You always want them to show what they do. And then the last out of that area is verify data retention and disposal. That's critical. Meaning, if you want to work with the customer or the third party, fourth party, that's great. In the data retention, then look at what is the disposal process if you're walking away from the said vendor, and what does that look like?
It's vital to remember, by delivering or selling off the asset into the secondary market does not absolve you of these obligations. You need for record retention purposes to retain this data. So, do not think that, for the records, for the assets that you sell off, you are absolved of the obligation to protect this data. The compliance verification I addressed earlier, from a high level, everyone's subject to the GLBA obligations. The New York DFS Part 500, if you're regulated by the state of New York or if you're not, this is probably the most comprehensive framework or guide from a regulatory perspective, detailing what exactly you need to do and how you need to do it. Obviously, FHA, VA, and the GSE obligations, and your state regulators and the CFPB. What are your obligations? Just because a new administration is entering on Monday, that does not do not think that examinations are going to get easier. States will most likely increase their examination and the breadth of their examinations based on the presumption that the federal government may be dropping off or may become more lax in their examination enforcement processes. Finally, these are all the artifacts that need to be retained throughout the process that represent what you did, how you did it, and the sufficiency for which you did it. Not only for you as a regulated institution, but as it relates to your vendor and your vendor's vendors. So doing it is great, but evidencing it is vital. Ensure that you retain excellent records of your vendor management platform, program, and oversight, and see it all the way through. We find ourselves at the bottom of an hour. It's amazing we got through that material in 30 minutes or less. Thank you, Scott.
You're welcome. Glad to be
Thank
here.
you both. You did great in 30 minutes. I just wanted to thank everybody for attending today's webinar. There was a great question that we will follow up with after the webinar today. And we will also be sending out the recording and the slides by the end of the week. Thanks all for joining. I hope you have a great day.
Thanks all.